This is Debt Free in 30, where every week we take 30 minutes and get practical advice from industry experts about personal finance and living debt-free. Here's your host, Doug Hoyes.
A few weeks ago, I got a letter in the mail from a person who read my book, Straight Talk on Your Money, and she said it was the greatest book she ever read. Actually, she didn't say that, but she did say it was easily readable, so that's good. And then she also said, and I quote, "In terms of your book, if I may provide one constructive comment, it might be appropriate to be reminding individuals who have the misfortune of losing their employment or being injured in accidents of the importance of getting legal advice so they will know their legal rights. Too often we see clients who did not know they could access benefits after a car accident, especially if they were a pedestrian, or individuals who quit their jobs and did not know they might have actions for wrongful dismissal or entitlement to disability benefits through a group insurer. And so far, at least, most damage awards are non-taxable." Interesting. Well, that got my attention because I know that there are many people who get into financial trouble as a result of being in an accident or getting injured, and that causes them to lose income, and they have expenses related to their injury, and so they have no choice but to use debt to survive. So, is it possible to recover some of those costs if you are injured in an accident? How does that work? When should you talk to a personal injury lawyer? To find out, I'm joined today by that very person who sent me that letter, so let's get started. Who are you and what do you do?
I'm Lisa Morell. I'm a personal injury lawyer in Kitchener-Waterloo. I have an office on Victoria Street, and I specialize primarily in car accidents, but other sorts of insurance disputes as well, disability claims, entitlement to Canada pension, but we do a lot of car accident work.
Excellent. We're going to talk about that today, and so thanks for being here in our Kitchener studio, and thanks for reading the book. So let me start by reading my standard disclaimer. This is my show. I get to pick the guest. No one gets paid to appear on the show, and no one can pay me to be on the show.
Wait a minute, I don't get paid?
No, there's no payments here. And of course, it's not a commercial for our guests. I've got you on the show because you got some stuff I'd like to hear about. That's why you're here. So, and yes, I do get the irony that we got the personal injury lawyer and the bankruptcy guy talking. So that's those are two interesting professions. So let's get started with, I guess, a general question. What is a typical person that you would typically help? So you said you do a lot of car accident work. So walk me through that scenario then. Someone's in a car accident. What kind of car accident are we talking about? They get rear-ended? What happens?
Well, someone's in a car accident, and the accident could be their fault, or it could be the fault of the other driver. A lot of clients don't realize, even if the accident is their fault, that they have entitlement to benefits from their own insurer. That's what no-fault insurance is. It's an entitlement to benefits from your own insurer, medical rehabilitation benefits and income replacement benefits, those sorts of benefits. You're entitled to those from your own auto insurer, even if the accident is your fault.
So that's what no fault means. It doesn't matter who did it. So I'm in a car accident, whether I caused it or didn't cause it. I talk to you, and then what are the next steps that you would take?
Well, I would advise you to notify your own insurer if you've been injured, and then you submit an application for accident benefits, which is a form that's about 33 pages long with various entitlements depending what category you fall in. If you're employed, there's an employer's certificate, and they're all called OCF forms. So they make it fairly complex for the average person to sift through if they've just had the traumatic experience of probably being injured in an accident. And your own insurer has the benefit of something called a minor injury guideline. So if you don't have a fracture, you probably have a sprain or a strain, which sounds like it's minor, but a sprain or a strain's probably not minor if you don't get better in like a week. Mm-hmm. If you don't get better in like a week, you probably need some treatment, and you probably need a lawyer to assist you in working the file to get you out of that minor injury guideline, because there'll be a whole lot else going on. If you deal with your insurance company directly, they'll be very happy to help you and refer you to insurer preferred clinics and referral sources that won't be active in terms of trying to get you out of this minor injury guideline. Because if you're in the minor injury guideline, your entitlement to medical treatment, the cost is capped at $3,500, whereas the policy that you've paid for would provide access to up to $65,000 for medical rehabilitation benefits and attendant care for a period of 5 years following the accident. So if you're hurt in an accident and you're not getting better after a week on your own, and you're perhaps used up the minor injury guideline, so you have no access to any more treatment, you're in a bit of a rut. And even if the accident is your fault, you should be seeing a lawyer who could assist you in accessing treatment, which could result in a settlement down the road.
And so in my head, I'm thinking, well, I go to a lawyer because I'm going to sue someone. But the way you're describing it, no, that's not how it is going to work all the time, maybe even most of the time. It's just someone who understands that, yeah, here's some basic rights that you've got. You have to have someone who is at least willing to push back on the insurance company, for example. That's really what you're describing. Am I right?
That's right.
And so, making up numbers off the top of your head, of the people who come to see you that you help, how many times, what percentage actually end up going to court and having to sue, as opposed to how many times are you able to just, through discussions and moral suasion and letters with the insurance company and whatever, get the client what they need?
Well, in terms of the accident benefit claim, any disputes go to a tribunal. It's a one-person tribunal, and the submissions could be done in writing. There's various formats for the hearing. And in certain circumstances, you might have the right to sue the other driver if the accident's the other driver's fault. Now, I still see people regularly who think no-fault insurance meant that you can't sue the other driver anymore. But it's nothing to do with whether you can sue the other driver. If the accident's the other driver's fault and you don't get better from your injuries and you have permanent and serious impairments, or if you lose your job or you don't get back to work, you have to meet a certain level of impairment. But if you've got an injury and you're not getting better and it's affecting your life, you probably meet that threshold. You probably have a claim against the at-fault driver. And now, suing somebody and going to court these days are really two separate things. We issue statements of claim and serve them. That's suing someone. We do that all the time. And generally, all of these matters, even for the other driver, are handled by their insurer. And if the other driver doesn't have an insurer, then your own auto insurance policy requires your insurer to respond to the claim. So even if the driver is unidentified or something, you would still have a claim that you could get an insurer to respond to. So we sue insurers and we sue other drivers all the time, but very few cases in the province of Ontario actually go to a trial.
Because there's all these other mechanisms that you described. So I'm in an accident. What kind of costs can I recover then? So let's say I get rear-ended, I got whiplash, so I need some medical treatments. And let's say I have to be off work for 3 months. When I'm suing either making a claim to my insurance company or suing the other driver, do I have recourse for getting, my medical expenses covered, for lost income, those sorts of things? What would be covered?
Well, in terms of the accident benefit file or the file with your own insurer, which I sometimes call a treatment file, they are obligated to pay for treatment costs up to a certain amount, which is $65,000 if you can get out of the minor injury guideline. But you have to work with treatment providers who are licensed to bill the insurance companies directly. And you also have to access your collateral benefits first before you access the benefits that are available.
So what do you mean collateral benefits?
Your group, like if you have benefits through your employer, if you have some coverage for physiotherapy, the physiotherapist you see on the auto accident will bill it to your group insurer first, and then they pick up the shortfall.
And what about lost income then? Is there any ability to recover some or all of that, or is that not possible?
From your own insurance company, you can get 70%, I think, of your gross income up to a maximum of $400 a week. And then you can look to the at-fault driver for the shortfall. So you can basically get back most of your income. In terms of what you can recover from your own insurer, the important question is going to be, what coverage do you have? There are a lot of optional benefits out there that can be purchased at a minimal cost. It makes the premium of your policy increase slightly, but it gives you access. If you're hurt in an accident, it gives you access to benefits that are 10 times or 50 times better than what you would have if you hadn't purchased these optional coverages. And very few people know about these optional coverages. Brokers have been inconsistent in terms of telling people that they should buy these optional coverages.
So in terms of practical advice for people who are listening, because that's kind of what this whole show is about, I guess there's the first piece of practical advice. Understand what insurance you have and understand what your options are, because there may be, for a relatively minor cost, additional insurance you can purchase that covers a whole bunch more than what your standard policy would cover.
That's correct. And there's all sorts of optional benefits that are available. For example, you can increase your income replacement benefit from $400 a week up to $1,000 a week, which would be very helpful if you're in an accident and you make, about $1,000 or $2,000 a week. You're not going to want to live on $400 a week. That's going to be a bit of a hardship.
And so if I'm with a company that has a group insurance plan, obviously it'll be pretty much standardized. What you're talking about is talking to an insurance professional about purchasing additional coverage. Is that typically
on your auto policy?
On your auto. I see. On your auto policy.
They used to have all of these coverages. Many of these coverages used to be included in your rate. And then as they've talked about, trying to keep insurance premiums low, they then have reduced the amount of coverages by making what used to be standard coverages now optional coverages, and telling consumers that now they have the option of just buying what they need. But the reality is that most people need most of those optional coverages. They just might not know to buy them. Gotcha.
So that's a very good point then. So understand what you're purchasing when you're buying your auto insurance. Don't just necessarily default to the absolute minimum, because for a slightly increased cost, and obviously it's going to be different in every case, you may be able to get a lot more benefits. So you got to really look ahead. Well, if I did get injured in a car accident and I was going to be off work for a period of time and I was going to have additional medical costs, there are insurance policies that can cover most or all of that, is what you're saying.
That's right. You can have better coverage, or you can have very standard minimal coverage.
So when is it that someone who's been in an accident should approach a lawyer? I mean, if it's a minor fender bender, I'm not injured in any way, okay, I mean, should I still be talking to a lawyer? At what's the threshold where you say to people, at the very least, you should give us a call?
I think if you're not better in 2 weeks.
2 weeks.
Because I think that if you really have a minor injury guideline and you could be treated within that framework of $3,500, I think if you didn't have any treatment and you wait 2 weeks, you'll be better.
Probably better anyways. Yeah. If you whack your arm, well, I guess it's going to get better on its own. If you break it, it's not going to get better on your own. So let's say that's my injury. I broke my arm. Now, that's not a hard thing to fix. It takes time, but they put a cast on it and I'm good to go. So in that hypothetical situation, should I be talking to a lawyer about that? It's going to take longer than 2 weeks for my arm to be fixed, but I guess I can be back to work pretty quickly. Where do you draw the line?
You probably should talk to a lawyer if you have a fracture, because then you're not in that minor injury guideline. You're automatically out of the minor injury guideline. And if the accident's not your fault, there might be some recourse to compensation from the driver who caused the accident. And even a fracture, depending on your age and everything else, probably will have some ramifications. In terms of your immediate, even personal care, you might require some assistance now in getting dressed or with your doing your hair.
You can't tell on day one what the long-term implications are going to be. And in my world, there's the Ontario Limitations Act, which determines when a creditor can sue someone who hasn't paid their bills. 2 years is the standard limitation period. How does it work in the case of a auto accident? Is there a period of time where I have to, contact the insurance company, file a claim, talk to a lawyer, all that kind of thing?
You should really, if you're hurt in an accident, you should let your insurance company know right away. And they generally like you to put your application for accident benefits in within 30 days. That being said, there's lots of occasions where they're later than that and they're accepted by the insurers because it depends on the circumstances. There's lots of people who are in accidents and don't realize that they have access to accident benefits because they don't know, they don't have auto insurance themselves. If they're a pedestrian and they're hit by a car and they don't have auto insurance, they may or may not find out from the at-fault driver that they have access to that policy of insurance.
So the default position would be, well, if you're not sure, talk to a lawyer. So let's say I was in an accident a week ago and I'm still feeling not, quite myself. So I give your firm a call. At what point do I have to start paying you for your advice?
Oh, we don't charge anything unless we obtain a settlement for someone.
So
we
talk
there's
on
no charge at all. Like some firms, there are some charges for something called disbursements, which that could be like costs of obtaining medical reports or court filing fees or various fees that we'll have to pay along the way. We charge absolutely nothing to our client unless we get them a settlement. And there could be other reasons. I mean, if they get better, they might not meet tests to get compensated. The claim against the at-fault driver is subject to a 2-year limitation period. And it's also based upon having suffered a permanent and serious impairment that significantly impacts many of your activities of daily living. So you might not know until around the 2-year mark, which is considered to be, a point to assess your maximum medical recovery. You might not know if you've got a permanent and serious impairment. I see many clients who sustain, for example, a whiplash injury or a soft tissue injury. These are all words that are designed to make it sound like your injuries aren't significant.
Soft tissue.
Tissue or whiplash, but they could have sustained an injury to their neck, which is causing them a great deal of pain, that initially after the accident, they think, oh, well, I've sustained a whiplash injury. I should be better in a few days, a few weeks, a few months. But what if you're not better in 2 years? Then it's looking like maybe it's a permanent injury, or maybe at the 1-year mark, you go to see your family doctor and your family doctor sends you for a diagnostic test and you find out there's a herniated disc and it's not going to get better. So you might not know until the 1-year mark that you've got a permanent and serious injury. So this limitation period hypothetically runs from when a reasonable person would have known they weren't going to get better. And that certainly depends on the type of injury. So it's possible to sue well beyond the 2 years, depending on the nature of the injury. If you lost your leg, for example, I think you probably know on the day of the accident you've sustained a permanent injury. But I see so many clients who have sustained different types of soft tissue and whiplash injuries that result in various things. Like if you've got this whiplash injury to your neck, the next thing you know, you've got headaches, or you can't sleep at night, so you're fatigued during the day, which might make you irritable, and then you're irritable with the people around you who are all irritable with you, and the next thing you know, you're feeling depressed. And maybe you can't work and you've got some financial pressures, so you need to see a psychologist. And, who knows when this is all going to get better.
Yeah, so there's a lot longer of a time frame where things can happen. So the default position then is talk to a lawyer. That kind of makes sense to me. So when I phone up a lawyer, whether it's your firm or someone else, what are the questions I should be asking then? What do I need to know from my lawyer? I mean, the obvious question that comes to my mind, if I may answer my own question, is, so where are you guys?
Well, we're here in Kitchener.
So are you local?
We're local.
And why is that important? Are there meetings that we're going to be having in person a lot, or is everything done over the phone and it doesn't really matter where the lawyer is?
Well, I mean, it depends on what type of practice the lawyer has and how the lawyer prefers to practice, and you want to find somebody who would be compatible with what your needs are as a client. I think for most people, a good indication as to whether they would want someone to represent them is the person willing to meet with them and provide them with a consultation, or are they dismissed when they call with a suggestion that, why don't you call back in a year if you're not better, or something like that. If they're not prepared to spend the time to meet with you up front to find out if you're hurt, that might be an indication that,
what kind of service are you going to get in the future?
If you are hurt.
Yeah, if you're going to brush me off right at the start, then we probably aren't going to have a great long-term relationship. And then in terms of costs, you already mentioned that at your firm, you'll pay us when we win. And up until then, there's nothing. Obviously, you're doing it on a contingency basis. There are other firms that are going to want some money up front. They got to order the medical test. They got to do that. So I guess that's another question that would be obvious to
And there
ask.
are some firms that just want to act for you if you've got a permanent and serious impairment and meet that test to get money from the at-fault driver, but they don't really want to help you with the first part, the accident benefit file.
Which to me is probably the most important part, because that's going to be a very common thing in virtually every situation where the permanent impairment, big lawsuits, that's a very rare thing. So if that's what you end up helping me with, making sure all of this 35-page form gets filed and I understand what my rights are, how do you get compensated in that case then? Is it a percentage of what I ultimately receive? Is it an hourly rate? How is it going to work in that case?
Well, there's a lot of cases that, that you get settlements on the claim against the at-fault driver and they're not, people are getting better, or the limitation, they don't have to go to trial, is what I'm saying. There's lots of cases that are in between. And the accident benefit file is key because that's how people access their treatment after the accident, which documents their injury and also helps them make their recovery. In terms of how we're going to get paid, we're going to charge a percentage, but it's going to be less any contribution that either insurer might make to your costs. On the first party settlement, it's more file, the accident benefit file. I'd say at this time, it's fair to say it's uncertain if there's going to be a settlement. So it's uncertain if our client's going to have to pay us on that first party file. Gotcha. And that's for a number of reasons. There was a study done a couple of years ago called the Marshall Report, where they actually recommended getting rid of full and final settlements, which at this time can happen after the 1-year mark on the accident benefit file, which means you won't get a settlement on that file. So that will, if that happens, that will probably mean you'll have to fund counsel privately if you want them. And then we've moved to a new tribunal called the Licensing Appeal Tribunal, where there are no cost awards for successful parties. So if costs are incurred to advance your entitlement to treatment, the insurance company doesn't have to pay them.
So when I'm talking to the lawyer up front, I should be asking about that. So, okay, assuming that the scenario...
What if there is no settlement? Right. What happens then?
And then what's the potential obligation for costs on my point of view? And obviously, I assume you can't tell right to the penny, here's what it's going to cost, but I assume you'd be able to say, well, in ballpark figures, these are the number of hours we're going to have to put in to help you with the forms and doing this and doing that. Here's what you're likely to have to incur. Is that how it would work?
Yeah, more or less. I mean, the issue is when you meet with a lawyer, you have to find out. It's all well and good to say that it's going to be contingency and you're going to get paid out of a settlement. But what if there is no settlement on either file? How much are you going to have to pay? How's the lawyer going to get paid?
And that would be an excellent question to be asking.
What if you get better? And that's the reason that there's no settlement. Or what if you decide that you want to get a different lawyer? Maybe you've hired some lawyer from out of town and you found out that you don't know who's really acting for you and you're not happy with their service, and you want to change to a local lawyer, for example. Then what is going to happen with the bill for the lawyer who's in Toronto? So there's retainer agreements that spell these things out, and a lot of it's quite standard for these retainer agreements to provide that if you don't cooperate with referrals, or if you change lawyers, or if there's no settlement, that you have to pay the lawyer on an hourly basis. Now, in our case, I don't. It's very simple. Retainer. If there's no settlement, there's no charge. But other lawyers are more interested in pursuing costs incurred for clients who get better. And I've found, interestingly, I've only had a handful of files that I've closed because clients get better. Because most often by the time somebody comes to see a lawyer, even if it's a couple weeks after the accident, they're coming to see a lawyer because in their mind they're worried that there's something that they might not get better and what's going to happen. So generally, I don't close very many files because clients are better. Which
is unfortunate, but that's you're right. That's why they're coming to see you. So okay, there's going to be an upfront retainer, and so the client wants to understand what that is, and that's potentially what their obligation is. Now, you mentioned the word referral, and so this is the last question I want to ask you about, which is, I hear all these ads on the radio all the time for different, lawyers, particularly in Toronto and bigger cities, not so much in Kitchener, I don't think, but, call us and we'll help you out. And I've read stuff in the media, and I don't know if everything I read in the media is true or not. I assume if it's in the newspaper, it must be true. But some of these law firms are really just referral sources. So you call them up and they take all your information, and next thing you know, I'm dealing with some lawyer somewhere else. And that kind of worries me because I phoned company ABC. I thought I was going to be dealing with company ABC. Is that something that as a consumer I should be concerned about? It seems like a worry to me. I'd kind of like to know who I'm dealing with. If I call your law firm, am I going to be dealing with one of your lawyers, or is there the chance you're firing me off to somebody else?
Well, referral fees have been permitted for a number of years by the Law Society, and they've now, they've become a subject of debate because of how they've been used in different circumstances to funnel clients to different sources of referral fees, I suppose. Mm-hmm. I've never really been involved in referral fees. I find personally like I have some sort of a question about it because often, I've been practicing law in Kitchener for almost 25 years this coming February. So, a lot of people know me. So they'll call me up when they've got a problem, a family law problem or a workplace an employment problem, different problems. And they'll say, I know you do personal injury, but, I need a real estate lawyer. So I've always thought that the best thing is for me to try and recommend a lawyer based on my personal knowledge who I think would do a good job for the person or who I think would be a good fit with the person who's calling. And I see that as helping me out because then it helps me find a constructive way to deal with the inquiry. Mm-hmm. But I think it would be different and referral fees are always supposed to be disclosed, and I don't think that they are. I think it would be different if I said, I think Bob would be the best lawyer to help you with your family dispute, but Mike gives me, he gives me $100 for every client I send over. So I'm going to recommend Mike. I just struggle with it ethically, how referral fees affect professional judgment.
Yeah, and your business from that point of view is almost exactly the same as our business because there's lots of companies out there that are nothing but referral agencies. You call them up, Joe the debt guy, and Joe the debt guy isn't actually going to do the work. He charges you some kind of fee, or maybe he doesn't. He then refers you to somebody, and then there's the referral fee paid back, and that's how he makes all his work. So, and you're saying it's similar in your business, but you and I have the same approach. If someone calls me up and says, yeah, I need some help with my taxes. Well, I'm not a tax accountant, but I do know in your town, here's a guy who's really good. And we're exactly the same. We don't accept any referral fees either, because if I refer you to the best person for the job, you're going to be happy. And then when your buddy needs my services, you'll refer them back to me. And that's kind of what you're describing, right? That lawyer will then, or the community in general knows who you are. The work all comes back to you anyways. You don't have to worry about referral fees. So I guess the final question to ask a lawyer when you're making that initial call is, so who's going to be doing the work? Is it going to be someone at your firm or somebody else? Is that not a basic question to be asking then?
Well, I think that's a very fair and prudent question to be asking, because I have clients who sometimes come after they've been to see a firm in another city that is a large entity, and they're like they've never met the lawyer. They're dealing with paralegals and they're dealing with clerks, and they've never met the lawyer.
Yep.
I think it's important these days that the lawyer. People expect it. People expect their lawyer to be accessible to them, to return phone calls, to answer emails, and to have the time to meet personally with them along the way to explain things. And in the case of a car accident or a personal injury action or a lawsuit, these things are important because there's a lot of concepts that are relatively complex.
Which is why you're going to a lawyer.
So you need somebody to sit down and take 10 minutes and explain to you what it is when you can ask them questions to clarify so that you understand. We're living in a society now where we think, everything can just be done by electronically, right?
Or Google.
Yeah,
I can look it up on Google and I'll be fine. But yeah, and that's why you go to a professional. So I think it's great to go to a professional, but it's also great to understand your rights and understand the questions you're asked, which is exactly why I wanted you on the show. So what final advice then would you give people who are listening to this today? If they've been in an accident, they know someone who's been in an accident, what kind of things should they be thinking about? What's your general advice?
they need to take the time early on, as early as possible. If they think they've been hurt, it's really important to take the time to find a lawyer who will take the time and sit down with them to discuss their particular situation, so that they have an understanding and they have a plan if they don't get better. And they have access to a lawyer who can assist them in making these referrals for treatment. The accident benefit system creates a really complicated way to access treatment. It's not, a lot of people come in, they think it's going to be like their group insurance. Their group insurance says you can spend $500 on glasses. You go to any optician, you get your glasses, you submit your invoice, or maybe it's even paid automatically at the till, and the insurance company pays for it. It's not like that. That's why you need a lawyer. How it is you have to figure out if you're in this minor injury guideline or not. You have to find good treatment providers who are licensed on what's called the HCI system. They are licensed to bill the insurer. It's very difficult to get treatment providers who are not licensed on this system to bill the insurer and have the insurer pay for them. Yes. So, and then every treatment plan, if you have access to $65,000, every treatment plan has to be prepared by one of these licensed treatment providers. And then the insurance company has the option to decide if they're going to approve the treatment or if they're going to deny the treatment. And if they deny the treatment, then you have to go probably for an insurer exam so one of their doctors can decide if it's reasonable and necessary. And all along this way, there's different pitfalls. You could have treatment providers who have you sign a paper saying that they can just keep treating you even if you're not approved, and then at the end of the day, you don't have a lawyer and there's a big bill for all this treatment that the insurance company should be paying for. It's just key, because it's a complicated process, that you have legal advice early on so that you know what you're dealing with. Otherwise, you're left with doing what your insurer recommends you do.
Yeah, which may not be in your best interest. So it's a complicated process. That's why you need to consult a lawyer. So that's, I think, excellent advice. So how can people find you? What's the name of the law firm? How can they track you down if they've got questions?
It's Morell Kelly. We have a website. It's www.morellkelly.com. And we have a fairly simple process where we just have a client complete a confidential online intake. And the majority of people who complete an intake, I have them in for a consultation.
It's simple as that. You sit down and take it from there.
Meeting clients is a key part of this type of practice, because there's so many issues that arise, right? I mean, somebody then gets, they get sent to a doctor hired by the insurance company. There's all sorts of things that can happen. What if the insurance company is trying to send you to Whitby? Do you really have to go to Whitby to have a general physician look at you to see whether you need another course of physiotherapy? Aren't there any general physicians closer? Yeah. That's why you need to have access to a lawyer who could, say to the insurance company, find a general physician in Kitchener. My client doesn't have a day to go to Whitby.
And that's why the local representation is important. So excellent. Well, I think that's very good advice. Lisa, thanks for being on the show.
Well, thank you for having me, Doug.
Thank you. I appreciate it. So that's our show for today. We'll have a full transcript and links to everything we talked about today, including links to Lisa's website so you can track her down over at hoyes.com. That's HOYES.com. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.